The second case on this morning's docket. I see our chargers are leaving. Thank you for coming. Thank you. Council, if you'd give us a moment while they filter out, that way you're not distracted.
May it please the court. Excuse me. Meryl Carver-Allman, Capital Appellate Defender, on behalf of Mr. Sherman and Chief Justice Nuss, if I may please have 2 minutes for rebuttal.
2 minutes is granted.
Thank you. I want to touch on parts of all three issues today, so I'll just dig in on this misconduct issue first. The first question, as this court is aware, is this misconduct? Were the comments outside the wide prosecutorial latitude? In our Kansas cases that we have that have used these sorts of puzzle and Wheel of Fortune analogies, that would be primarily Crawford, Stevenson, and Jackson. This court has made it clear that prosecutors are tap dancing on the line when they use these kinds of analogies, and whether they cross the line or not seems to depend on kind of how much of the picture is showing when they say this is, is this reasonable doubt, and also whether they clarify immediately after, make some clarification that I'm required to prove every element and, make a good solid clarification of the burden of proof afterwards. And our argument here is that they did not make a good clarification afterwards. The state talked about gaps in their evidence, and a quarter of Mount Rushmore was missing in this analogy that they used. So for that reason, we would argue that this is misconduct. The state argues a couple of unpublished Kentucky cases that specifically use the Mount Rushmore analogy, but those cases, I think it's important to note, first of all, particularly in Monk, the court didn't say that it wasn't error. They said it wasn't reversible error, which I think this court knows the difference between the two. I'm not going to explain it. And also, they were looking at it under a palpable error standard, which, if I'm interpreting Kentucky law correctly, is something like our manifest injustice standard. So it's a higher standard of review than we're really dealing with here today. So I don't think that those cases are really that instructive. And then we go on, assuming it's misconduct, we go on to figure out if the statements prejudice the jury and deny the defendant a fair trial. First thing up is obviously gross and flagrant. We can argue about, because this trial did take place, and that's another issue, obviously, several years ago now. We can argue about when the kind of analogy cases came down related to this trial. But the bottom line is that there are lots of cases pre-2007 dating back into before most of us were born, maybe even, that say that prosecutors should not try to define reasonable doubt. That's a clear rule. There's no question about that, and it's an old rule. Also, the drawing was prepared ahead of time. Clearly, this was not some poorly worded argument that came up on the fly. In this particular case, the judge had already said 2 times in voir dire and at the instructions conference, hey, I don't think we need to try to define reasonable doubt. I think the judge was very aware that that's, you get into that at your peril. So I think the prosecutor had been adequately warned, and therefore the conduct was gross and flagrant. And I've kind of floated this issue in my brief that we should subsume ill will into the gross and flagrant analysis. And I think I've set that out about as well as I can in my brief, so I'm not going to repeat that. But basically, they're very repetitive. If I'm going to stand up here and argue ill will to you today, basically I'm going to say the same things I just said for gross and flagrant. It was premeditated. It was done after the court had said multiple times, hey, we don't need to define reasonable doubt. So assuming that ill will is still a valid factor, which we're arguing that it really shouldn't be anymore, I think there was also ill will here. And then we get into
Do you think in our analysis there's any room, if we have indications in the record, that there's something almost vindictive or personal about the way in which a prosecutor approaches a case as against a particular defendant, and that might be ill will as opposed to just being a gross and flagrant violation of our past cases?
I think that fits into gross and flagrant. If you look at gross and flagrant is, and this is, I'm quoting from the state's brief actually here, gross and flagrant is conduct that is repeated, emphasized, violated a clear or long-standing rule, or violated a constitutional right. Ill will is conduct that's deliberate, repeated, or an indifference to a court's ruling. And so I understand there's that element of maliciousness, sort of, that we associate with ill will. But I really think that that makes more sense as sort of a part of the gross and flagrant analysis. Sure, if it's there, you should consider it. We'd love you to consider it. But it doesn't make sense. And historically, if you look at the cases, as I've set out in my brief, it doesn't make sense as an independent sort of factor that we have to talk about in every case, because it's not present in every case. And I think that the state's suggestion that we talk about prosecutorial error is actually not a bad one, because most of the time obviously where there is something malicious, we want to bring that to the court's attention. But most of the time, I don't think that the question of whether the prosecutor had dark thoughts in his heart, so to speak, it really doesn't have a lot to do with whether the defendant got a fair trial or not. I mean, you could make some pretty bad statements innocently. So I just don't think that, and I think maybe for a long time now it hasn't been a valid factor, but we kind of just, repeat our standards of review and go on. So, and this just seemed like a good case to challenge it. I had some extra time. I don't know.
Go ahead.
Go ahead.
Well, just to summarize, it sounds to me like making a pretty simple argument that once error/misconduct has been found, the only real question is whether or not the defendant was denied his right to a fair trial, and we apply a constitutional harmlessness standard to that.
I mean, that's certainly, because, if you look at the analysis, it's, we have, was there misconduct, and then did it deny the defendant a fair trial, and then we have these subparts that we've looked at for the second question. And I think that gross and flagrant, that makes sense for the analysis.
Does it make sense because it is helpful in answering the harmlessness question?
Exactly.
So it's essentially a factor to be considered as the court answers the harmlessness question.
Yes, I would agree with that.
And so you've reduced the three factors to two. Number one, basically the amount of the evidence, and then if there was gross and flagrant misconduct.
I think that's correct. Yes. And the third factor, of course, is the harmlessness. Here, we would argue we had not overwhelming evidence. There was conflicting stories. Mr. Lewis, he wasn't a co-defendant in the case per se, but he was there at the time of the crime. If my client didn't do it, then he probably did. Definite pointing fingers at each other. And Mr. Lewis was also the person that had ensnared this victim here for the purposes of prostitution. My client's DNA wasn't found anywhere. Mr. Lewis's was found, I believe, on some papers in the victim's wallet, if I'm correct. And also there was a jury question that asked specifically to read back the prosecutor's rebuttal, which is where this analogy was presented. So, and they didn't end up actually reading it back. The court decided that they weren't going to do that, but the jury was clearly interested in that portion of the closing argument. So I think that shows that they didn't just disregard it. If there are more questions, I'd be happy to answer them. Otherwise, I'm going to move on. The mistrial issue, I filed a reply brief on that as to the state's arguments that this was not preserved for appeal. I think putting the burden on, or arguing particularly that it somehow invited error to argue that we had to re-object somehow anticipatorily to our motion in limine that we filed prior to trial. I just don't even know how that works, actually. So I think that's, I've addressed that in my reply brief, so I'm not going to go over it here. One thing I did want to talk about was the state argues that this evidence came in through the defendant's own testimony, so therefore it's harmless, but that was after the tape had already come in. So basically at that point, they were dealing with the bad ruling, and I don't think that should count against my client in terms of the harmless error analysis here.
Don't we have case law that says we look at the entire record when we conduct a harmlessness review, even if we're dealing with this exact situation, i.e. a denied motion for mistrial?
Sure, I think you can, but I think that assuming that this would have come in, assuming that my client would have gotten up and testified even, maybe he would, maybe he wouldn't have, I'm not sure, after...
Well, we're not
he had to explain what was said on the tape at that point.
Did he? Wasn't there an admonition?
There was an admonition, but as the defense attorney said at the time, even, and I think this was in arguing the motion for mistrial, said, they know he's on probation. We don't want them to imagine what he was on probation for. We want to tell them at this point. I mean, once that bad evidence has come in, you've got to deal with it. You can't just.
So the defense counsel essentially ignored the admonition or its effectiveness and went ahead and made a calculated, I guess, a calculated determination that he's going to allow this evidence to come in to make an explanation.
Which I think he had to do after it came in incorrectly.
But wasn't this cross-examination of the defendant?
So it's by the state, right?
Right. So why is that calculated defense strategy when the state's cross-examining about that?
Well, not to object. He didn't object to it coming in. He didn't jump up and down right away and say that not only violates the motion in limine, it violates your admonition and everything else.
He didn't object to it there.
He didn't do that.
He didn't object to it there. And again, I think at that point he may have felt like it was better to let it come out and be explained.
Well, he didn't bring it out in direct.
He didn't bring it out in direct. Although I think that the state argues that he did. I want to look at that for my rebuttal. I may get back up and talk about that some more because I believe that the state's argument is that he did. Let me look at that. Lastly, because I only have a minute or so left here, I want to make sure that the court is crystal clear on my position on this speedy appeal issue because I know it's kind of confusing. I considered asking for a remand on this issue, but it just didn't make a lot of sense in terms of judicial economy because we have to show prejudice before we get anywhere. And if we don't win some other issue on this appeal, I don't think we've shown prejudice. But I don't want the court to think that I'm asking for sort of an advisory opinion either, because I think in Harris itself, clearly, the court made rulings on those first three factors and then remanded as to the prejudice and let the district court hold an evidentiary hearing on that. And that's what we're arguing should happen here. Obviously, we all agreed that the length of delay here was excessive. It was 7 years. The reason for delay, the state says that it's the defense attorney's fault. That is probably true. I can't say that it wasn't. It actually used to happen quite a lot, and it's kind of gotten fixed. But there was, for a while, there was a real problem of cases getting dropped because the trial attorneys would file the notice of appeal, and then the appellate defender office would never get any notification of that, and so then there would be this long gap between. But regardless of whose fault it is, I mean, I am part of the government standing here before you today. That's who writes my paychecks. So it's the government has a right or has a duty to ensure the speedy appellate process. And so even if it was the defense attorney's fault, that really doesn't matter here. My client filed the notice of appeal. He signed it personally. He wanted an appeal, and it took him 7 years to follow up, but he didn't have an attorney during that time. And frankly, I've had appeals take maybe not quite that long, but almost that long. So I don't know that that's particularly unreasonable, particularly for someone who's not legally trained. The first thing that gets said to most people about appeals is it's going to take a long time. So yes, that was a long time before he followed up on it, but I think we have to keep those factors into account. And then as to the prejudice, again, he has to have a colorable claim and show some other sort of specific prejudice. The colorable claim is what this appeal is about, and then I think we need an evidentiary hearing to look at those other issues.
Any questions? Thank you, counsel.
Thank you.
May it please the court.
Counsel, during your presentation, maybe the first minute, could you let our computer audience know what this case is about?
Sure. This is a case that occurred back in November 26, 2005 in Crawford County, where an individual was attacked, beaten with a heavy stick, resulting in multiple trauma to the head, repeated blows to the head that caused soft tissue damage to the scalp, multiple skull fractures, damage, and bleeding to the brain. They were able to develop a suspect. In this case, the victim in this case actually didn't pass away until several days after the attack, and the trial took place in 2007, which predates me being county attorney in this case, or the current county attorney, or being a prosecutor for that matter. Several years later, the defendant sends a letter to the court asking what's the status of the appeal, and that's what kind of tipped everyone off that there was nothing subsequently done by the defense attorney to withdraw and to have the court-appointed appellate counsel. The
And what was
court,
he convicted of?
he was convicted of first-degree felony murder and aggravated battery to a individual that he knew, Mr. Lewis, prior to the attack. He says that he was hit on the head with an object by the defendant, and that's the aggravated battery count. Regarding the misconduct, it is difficult, and I will tell you that I do believe that the wording that was used by the prosecutor at that time is problematic. Whether it rises to the level of misconduct, obviously, I think it depends on how the court determines it should be interpreted and what exactly was being said. If you look at the diagram itself, just looking at the four corners of the diagram, it is speaking about reasonable doubt. I believe on the top of that diagram it says, do you have any doubt that this is Mount Rushmore? But when you look at the words of the prosecutor and what was said, it appears that he was also talking about the credibility of witnesses and the weight of the testimony. That was the primary attack by the defendant in this case, that there are contradictions, there are credibility issues, and it is up to you to weigh those and determine, based on your common knowledge and experience, as to who you're going to believe. So, if this court finds that he was attempting to define reasonable doubt, then there would be misconduct. Now, we would argue that that would be harmless. At the end of the day, you would have not only the evidence that was presented, but also the defendant's words. The defendant's words that were damning, that had multiple inconsistencies, that were inconsistent to his initial statement to law enforcement. And I think, and I list in my brief, all of the evidence that the defendant in his own statements corroborated by not only other witnesses, but also the physical evidence in the case. So we would ask the court, if it finds that the misconduct did occur, to look at the evidence in its totality, the entire record, and find that it was harmless.
Is there any difference between the argument made by the prosecutor here and the Stevenson case, the Wheel of Fortune analogy, which we found was not misconduct, even though it scuffed the line?
And I believe it was Justice Luckert that wrote that opinion, that talked about, even though we find that it was not misconduct, be careful.
Sure, but let's just stick with the actual ruling of the
Right.
Stevenson court.
And I think
What's the difference between this analogy and the Wheel of Fortune analogy?
I don't believe that there's much. I think what made a difference in Stevenson is the number of letters that appeared in the Wheel of Fortune. That it would be, and I think that was the argument of the state, that there were so many letters, it would be difficult for a jury to actually break down. Well, they were asking, figure out this mathematical computation of how many letters were missing, and that is what reasonable doubt must be. And obviously, in this case, with only 4, it is different.
Well,
But I think the same concept applies. The same concept applies as to the Wheel of Fortune.
it would seem to me that it does, and it would seem to me that, as many of these sort of iconic images cases point out, people can recognize iconic images with very low percentages of the image actually filled in. So it seems to me that it's true, right? A slide of Mount Rushmore without Theodore Roosevelt, we all recognize what that is. The problem with those kinds of images, it strikes me, is not the percentage of the picture that's filled in. It's that you're showing the jury something that they already know what it is. And you're analogizing that to a case in which they know nothing about the case. They don't bring with them knowledge of the facts of the case in the same way they do knowledge of these iconic images, right?
Which is true. When this was said, they had heard all the evidence in this case. So they were familiar, not as familiar as Mount Rushmore, granted, but they were familiar with the facts of the case and the allegations being made by the state and the defense as well.
I've got a more fundamental problem, perhaps, is we have said that the district court should not instruct on reasonable doubt. Isn't that where we are? That reasonable doubt is not amenable to any further explanation or definition, and so there shouldn't be an instruction defining it?
There was I believe the State v. Walker case by this court that spoke about the jury coming back and asking, can you elaborate as to what reasonable doubt means? The court then went on, I think it was about a 2 or 3 paragraph response to the jury's question that spoke about reasonable doubt and how you can analyze it under this. And the court did find that by the court defining that it was reasonable, or that it was reversible error by defining that.
And if we are going to reverse a judge for attempting to define reasonable doubt, why would we let prosecutors do something that we preclude the judge from doing with regard to a legal definition?
Because the conversation just doesn't end there. You know, when you look at just whether or not it was an attempt to define reasonable doubt, you also have to look at the gross and flagrant. You also have to look at the ill will. You have to look at whether or not it was harmless.
Okay,
and I think that that second.
Okay, let me refine my question then. And I understand your harmlessness argument, but why would it ever not be error for a prosecutor to try to define for the jury a legal concept that we do not allow the district judge to define?
And I believe if you interpret the statements made by the prosecutor at that time to define reasonable doubt, I do believe that you can that it is error. Not, you know, it doesn't stop there, but I if you do find that it is his attempt at defining reasonable doubt, then I do believe that misconduct or error did occur, and then you obviously have to go to that second part.
And the way you want us to view it, or suggesting we might view it, is that it wasn't defining the concept, but arguing the weight of the evidence. Is that what you're saying?
The weight of the evidence and the credibility of the witnesses, because it was said at the same time, and it is inartful in the manner in which it was done. I'm not disputing any of that.
It's more than inartful because it was obviously planned. Well, inartful's usually, oops, I made a little mistake in the way I worded it. This was a planned thing. There was a slide, you know. I mean, we all.
And it was done in rebuttal.
Counsel, I'd like you to talk about just the weight of the evidence part of the harmlessness inquiry, because I mean, this is a he said case, isn't it?
It is.
What do you
however,
have? What do you have besides two people pointing the finger at each other? What else? What adds to the weight of the evidence that it was this gentleman versus the other gentleman who committed the crime?
and I think you just can't look at the facts of the actual crime itself, but look at everything else that was from the very beginning, from the moment they first met this individual, to the moment that he was attacked.
So I'm just asking you kind of, if you can, list for me what else there is besides conflicting stories from two people trying to make sure the other one's the one who gets blamed.
But it's not only the conflicting stories, but also the statements that corroborate each other. And I think that adds to the strength of the evidence. I understand that there wasn't DNA, that there wasn't fingerprints. The defense brought all of that out to the jury to weigh. But not only the contradictions and the finger pointing, but also the parts that the defendant himself corroborated that did occur. And I think that strengthens the state's case in determining the evidence and what the jury believed or who the jury believed to be more credible than not.
Okay, DNA aside, was there any physical evidence that corroborated?
You know, there was, I believe there was that video at the Walmart that showed after the fact, and I believe it was Mr. Lewis that had gotten things for his injuries on top of his head. That is something I think that also corroborates not only the written statements, but what actually occurred.
Okay, thank you.
And they were able to find those items, by the way, in Mr. Sherman's girlfriend's apartment. So that's just another component of the evidence that was able to be corroborated physically.
Can we
Counselor.
get to the motion in limine question? As I understand that their pre-trial, there was a motion in limine which both parties just agreed that any prior offenses, prior bad acts would not come in, which would include the fact that he was on probation and there was a warrant. And then the state produced evidence in the form of the videotape that didn't excise that information, and that was mistakenly played in front of the jury. The jury's then admonished not to ignore that information, in essence. And then during cross-examination of the defendant, the state then inquires from the defendant about whether he had a warrant, and the defendant then responds been placed on probation and failed to report. Then there's an inquiry, well, what are you on probation for? He answers, and then there's an inquiry about restitution and whether he's made restitution. And then that's when an objection. What is it that the state didn't understand about the motion in limine?
Well,
What allows you to violate the motion in limine through the questions?
First of all, the question that was asked to the defendant was, did you call 911? No, I did not. And why didn't you call 911? And then the defendant went on to explain a reason for that.
And he
the
said, I had a
defendant
warrant, and again, I thought Sherrod was a good friend of mine. I didn't want to call him. Why doesn't it end there? What allows you to then get further into the inquiry about what the warrant's for, what the crime was, whether he's paid restitution?
And I understand that. And I
What is
mentioned-
that all about?
And I mentioned that, you know, the decision by the court that it just doesn't open the door. I believe it was
it
the
doesn't.
Knight case.
It doesn't. And
Right.
what are you doing?
Keep in mind that there was a long history of precedent by this court that if the door is opened by the defendant, that once the door is open, it is open. So at the time that this was tried, you know, the court, defense counsel, or the state did not have that ruling that changed decades of precedent. So I think that the court needs to be aware of that and why the prosecutor probably pursued that. With that in mind, the defense attorney never once objected to any of those questions as well. And I think that is something.
So the
that,
lack of an objection gives you free license to violate a motion in limine? Is that what you're saying?
No, and I think that the court needs to determine, you know, the district court judge at the time found that it was not a violation of the motion in limine. And not only did the court give an admonition, but then it also gave a curative instruction. And then
As to the videotape.
as to the videotape.
But this is
And-
then post-videotape, after the admonition, isn't it?
It is. But once again, the prosecutor didn't lead as he could have in cross-examination. The prosecutor could have said, isn't it true that you were on probation? And I think that is a distinction that this court should take into consideration. I understand it was an open-ended question. And keep in mind, it's a valid reason that the defendant or the defense attorney would want that to come in.
I'm sorry, counsel, could I just make sure I understood what you just said? Did you just say it was okay, it was permissible under the order in limine for the prosecutor to ask the defendant if he was on probation? Even though the order in limine said that evidence of prior crimes was not going to be admissible?
The prosecutor did not ask him.
Oh, I thought, I just want to make sure I didn't mishear. Okay, thank you.
Yeah, the question that was asked by the prosecutor
Was about why
is-
you didn't call 911.
right, and this was his reasoning. And it makes sense that you would want a defendant would want to explain that, because if this was
Well,
in self-defense.
Well, he didn't ask. He said, then he went on to ask whether he had how do you know he had a warrant? Because he was on probation and he hadn't shown up, so he assumed there was a warrant. Well, what are you on probation for? And he says criminal damage to property. And then he was asked whether he owed any money as part of restitution. It's not leading questions, but there's certainly questions that, in my mind anyway, get to the very heart of the motion in limine.
And I understand that, and I understand your concern. My response is that once the defendant, it was believed at that time in 2005, or when this case was tried, that once the defendant had opened that door by volunteering that information, then that door was open.
By volunteering, he had a warrant that allowed then further inquiry into everything else.
I believe, and the case law would have indicated at that time that would have been permissible. And the fact that the defense attorney did not object to any of that, I think is also goes to show that they did believe it was important to address this issue regarding the 911 tape. I also believe, I mentioned that, and I know that counsel, my time's almost up, but
Continue.
counsel mentions that it's a red herring regarding the objection. This court has found that a defendant's failure to object to the false statements and to request a redaction precludes this court, the Supreme Court, from addressing the defendant's earlier argument that the trial court should not have admitted the evidence. I think that is something that this court should consider, whether or not it was properly preserved. When you're dealing with the redaction of the tape, I don't think it's a fair assessment to say the defendant or defense counsel assumed that the tape was redacted. I don't know how he could have assumed that. It would have been provided to counsel, that redaction. It was probably something that would have been spoken about, what portion should be redacted and what should not have been redacted. The tape was not in anyone's mind when they were talking about the motion in limine, and the court pointed that out in its ruling as to denying the mistrial. So I think that is a factor that this court should consider as to whether A, it was a violation of the motion in limine, and if it was, does it still require reversal? Keeping in mind that it was the defendant himself that volunteered that information to the jury.
Counsel, I had some questions about the prosecutor's conduct that I don't think we've touched on this morning, and it was conduct during voir dire. Are you familiar with that part of the record?
I am.
It appears as though he starts to talk to the potential jury about burden of proof, and then the judge cuts him off and says, well, I'll instruct the jury at the appropriate time on reasonable doubt. And then later the prosecutor says, well, let me use the example of a picture of a globe. I know it's small, and the judge says, I hate to interrupt you, but you should not be using demonstrative stuff on voir dire. If you would just please question the jury, I'd appreciate it. You can use that stuff in closing argument. And the prosecutor says, I will, Your Honor. And then the prosecutor says, well, let me go through one more example. Say it's a winter day, you've got snow on the ground, you come outside and you see some tracks in the snow. And the judge interrupts and says, you're being argumentative, and he said, I'll move on, Your Honor. So it looks like he's receiving some indicators from the judge at that time, I'll do the instructing on reasonable doubt. And then he comes back in closing argument with a prepared slide, I think in his PowerPoint presentation, he has Mount Rushmore. So what, if anything, do we make of all that?
I don't believe that some of the other analogies that were attempted during voir dire dealt with reasonable doubt analogy. There are two statements that are complained about by the defendant in this case. The first one is, everybody knows the burden of proof is beyond a reasonable doubt. It's the highest burden in law, but it doesn't mean that there's can't be any doubt in the case, because there's always some doubt. That's when the court stops him and says, you're defining reasonable doubt. He was not defining reasonable doubt there. That is not a statement that is incorrect. all the prosecutor was doing at that time was making a distinction between the actual burden of proof as beyond a reasonable doubt and beyond a shadow of a doubt, of any doubt, or anything to that effect. That is not misconduct, and I argue that in the brief. And that's statement number one. The next statement that the defendant complains about obviously is the one that was done at rebuttal. The other analogies or attempt to an analogy, I do not believe that it was an attempt to define reasonable doubt, and that's why the defendant has not made those arguments to this court as to that being additional misconduct. So that's how I would argue to this court, is that did not have it was not the prosecutor's attempt in defining reasonable doubt at those times.
And what was the reason then for the judge sua sponte to repeatedly interrupt counsel?
Well,
If it wasn't his attempt to define reasonable doubt, why was the judge doing that?
I have no idea. But if you look at when the judge interrupted the first time, there was nothing wrong with that. There was nothing wrong with that statement. The judge thought it was about to get or did cross the line, and that's when the judge says, no, we're not going to just stop. But that was not inappropriate. And our case law from this court indicates that that's not inappropriate for a prosecutor being able to explain to a jury or to differentiate the difference between beyond a reasonable doubt and beyond a shadow of a doubt or beyond any doubt. So I don't know why the judge stopped him in that first statement.
Earl, thank you. Any further presentation?
No, I do mention a brief part of my brief regarding prosecutorial error versus prosecutorial misconduct. I would like to ask this court to consider that and to use the term misconduct when it deals with issues of ill will and gross and flagrant, and to consider using the term prosecutorial error when it comes to an inadvertent or misstep on the part of the prosecutor. The term prosecutorial error is not foreign to this court. I believe it was Justice Stegall just in December of 2015, just last year, that he used the term prosecutorial error in looking at a case. So it's not something that is foreign. I don't think the analysis changed as I suggested in my brief, but something that I asked the court to give thoughtful consideration for, which numerous states have made that distinction.
Along those lines, what's your response, if any, to opposing counsel's suggestion that we actually should change the analysis, particularly with regard to the ill will prong? Do you have any position on that?
I do. And I mentioned this in the brief, if the court does do away with that ill will factor, then I think the term misconduct should be done away altogether, and everything just be called as prosecutorial error. I do think ill will is an important determination for gross and flagrant, as suggested or as mentioned by Justice Luker, because it does add that component of whether or not it was an intentional act by the prosecutor, either directly against the defendant, and I think that does go to gross and flagrant.
Along those lines, is there any real rationale for having a special harmlessness test for this error compared to other errors? If we're going to apply the constitutional harmless error rule, why don't we just apply it rather than to go through steps?
And I think that's another valid argument to be made as terms of how to begin analyzing these types of issues, because ultimately you will be dealing with whether or not an individual was denied a fair trial and whether or not his inherent constitutional rights were violated under the harmless error analysis.
Go ahead.
I just ask that you would affirm the district court of the convictions of this defendant.
Any further questions?
I think I do have one. I'm just trying to make sure that we're not going to lose something if we change to a strict constitutional reversibility analysis. So let's just suppose a case where there is evidence in the record of some sort that, and I'm not using the word evidence in a technical way, but just there's material in the record that would lead the court to conclude that there was intentional conduct or malice or malevolence of some sort on the part of a prosecutor. If we just go to a constitutional harmlessness standard, then there's really no place to consider that, is there?
Other than the court's duty, if it believes that that did occur, I think obviously the court has an affirmative duty to report that attorney.
Right,
to
that's
the
what I'm getting to.
disciplinaries.
Then we're just talking about it, but there's
Sure.
no ability of a defendant to rely on that. Even if it's really strong, I mean, there's more than a whiff that that's what was happening. It's not going to get the defendant anywhere. And so are we losing something in terms of ensuring the fairness of our proceedings? Because the prosecutor isn't just a lawyer. The prosecutor is more than just an advocate for the state or an advocate for conviction. The prosecutor is also a guarantor of fair trial. And that's really been the underlying rationale, if you will, I think, for having a special rule on prosecutorial. What we've called misconduct, maybe that's been a misnomer for the vast majority of cases. But there may be a few cases where it's not a misnomer. So do we lose something in terms of guaranteeing fair trial and ensuring that the prosecutor is part of that endeavor if we do away with some benefit to the defendant if there's been a demonstration of ill will or gross and flagrant?
Under a strictly harmless error analysis, two components that this court must consider is whether or not there was a fundamental failure in the proceeding, as well as whether or not it resulted in injustice. And I believe that conversation or those findings can be made under resulting in injustice. I believe
So
that
you
if
think
a
it's still
prosecutor,
part of constitutional harmlessness analysis?
I think it can be.
Okay.
I think under those two, I know that is one of your concerns, but
I just want to make sure we don't move too quickly to change the analysis if we're going to lose something. That's
And keep in
important-
mind,
that's important to hang on
I'm
to.
talking out loud as well, trying to,
Think
in
through
my
it.
mind,
We're external
figure it out.
processing.
Right.
Externally
While you're-
processing. Okay.
While you're thinking out loud, here's another question to pose. Does a defendant have a right under the Kansas Bill of Rights to the Constitution to a fair trial? Or is it strictly a federal right?
I'll be honest with you, this court has said time and time again that our Bill of Rights does not enumerate additional rights that are not contained in the U.S. Constitution. And I think that because that is contained in the U.S. Constitution, that is obviously something that would be applied to the state. And did you say defendant or the state?
Does a
Defendant.
defendant
Right.
have a right to a fair trial under the Kansas Constitution or the Kansas Bill of Rights to the Constitution?
I will tell you, I have always assumed that. I have not looked at it closely enough to have an academic debate on that issue.
And if for some reason a defense counsel alleged only a violation of his or her client's right to a fair trial on the Kansas Constitution, how would we analyze that claim? Would we analyze it under a federal constitutional error or a state error?
Those are tricky questions. And I think first of all, I don't believe that. They always raise both. So this may be just an issue of just academic, but assuming under your facts that they only raise Kansas, I think that this court first can make that finding that Kansas does provide a defendant a right to a fair trial under the Kansas Bill of Rights somehow. If it's not explicitly stated, then it would perhaps be implied. And if it is not, I think it would be a tough decision to then make that determination. What standard does apply? And I think that the court would have to apply whatever standard in Kansas and use the U.S. Constitution as a guide in making that analysis.
Would we look at KSA 6261, which talks about error committed by the trial court?
I believe so. I mean, I think absolutely that would be something that would imply that.
Very well. Any further questions? Thank you, counsel.
I appreciate your time. Thank you so much.
Could you take that question up before you proceed?
Wow, 2 minutes. Okay. Yes, there is a right to a fair trial in the Kansas Constitution, Section 5, Section 10, clearly. As far as how we would analyze that under the Kansas Constitution, and I've had this problem before this court, and the problem is that for so long we've said we just stay in lockstep with the federal Constitution, that we don't really have tests of our own. And I didn't get a chance to look up the statute you were talking about, so I can't speak to that, how that would apply off the cuff. But I think that's largely the problem with the idea that you're suggesting, is that we haven't. I don't know what the test is because there aren't really cases that tell me that. So I'd love it if we could develop more of that, because I think that we have a Kansas Constitution, and as a dear friend of mine said a couple weeks ago, Free State Patriots died in the mud to get that, so it should mean something. So I'm, all about that, but I don't know that I can answer your question as to the test. Justice Byers' question I wanted to address about whether we're losing something by taking out the ill will. I think Justice Stegall and perhaps Justice Johnson are taking it a little further than I argued, and I think that maybe we keep the gross and flagrant to reflect the concerns that you're talking about.
I'm just wondering, should any defendant ever get a reversal of a conviction strictly because there's a demonstration of ill will or something like it, some kind of malfeasance on the part of a prosecutor, even if the evidence is overwhelming? See, that's what's become the conventional of the last 15 years or so. Test ensures that there's a little window there where you might not have a conventional prejudice under either 6261 or the
Chapman test,
federal
yeah.
constitutional Chapman test, or both of them together, where you might not reverse on those bases because you have overwhelming evidence. Should a defendant ever, that's the bottom line question, should a defendant ever be entitled to a new trial simply because the assessment is it wasn't fair because there was prosecutorial, let's talk about those really extreme, an actual kind of malfeasance situation. And I don't know the answer to that, but I think that if you leave what we've done behind, and go to a strictly constitutional harmless error analysis, I'm not sure that you get to that question. And I just want to make sure we're not going to lose something that we value. Maybe we don't value.
And practically speaking, from my view and maybe slightly bitter view as a defense attorney, it doesn't seem to be working out that way. I mean, it seems like you can get up here and you can show that sometimes even the same prosecutor has said the same things time and again, and that doesn't really matter because you've got this overwhelming evidence over here. So I don't know that we're where you say we are anyway, I guess.
Let me offer a solution. Why don't we apply the Constitution even to guilty people?
That sounds like a good idea, Justice
then
Johnson. I like that.
Even guilty people get a fair trial.
I like that idea.
Okay.
Yeah. Lastly, I'm out of time, but with your permission, I just want to address this on the motion for mistrial, and Justice Rosen seems to have it well in hand, but record, Roman numerals, 17, page 136, is where this came in during the cross-examination, and the court, the defense attorney is very slow to object here. I agree with that, definitely. He says, I'm going to object, and then the court says, well, I think you've opened the door in your direct examination. I can't find anywhere in his direct examination where he opened the door. So to the extent that the defendant opened the door and the defense attorney didn't object fast enough there, I agree that that's perhaps a problem, but I think that everybody was kind of confused about what was actually going on here. I guess I'll just say it that way. And I mean, the record is what it is on that, but I think that there was definitely some confusion there.
Counsel, I wanted to go back to the colloquy you had a minute ago, I guess with both my colleagues, when you were talking about can there be conduct so bad that a defendant would be denied a fair trial regardless of the amount of evidence against the defendant. The conversation you're having seemed to be focused on ill will or malfeasance.
Mm-hmm.
I'm just asking, in your view, would that be expanded to any other area? For example, our test for misconduct and the prejudice resulting from it includes gross and flagrant conduct.
Say that.
Let's talk about gross and flagrant conduct.
Okay.
Is it your view that gross and flagrant conduct alone by a prosecutor, not ill will, but just gross and flagrant conduct, it can be so bad that that can deny the defendant's right to a fair trial?
Absolutely.
All right.
Yes. Yes. And again, I mean, we're still looking at, in the absence of malfeasance, we're still looking at, was it repeated multiple times? We're still looking at, here where the jury asked a question about it specifically. We're still looking at things like that. And that goes to a fair trial. And again, those are just guideposts under that fair trial overarching standard, I think.
All right. Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. That